Let me begin with what actually happened, stripped of the headlines, the all-caps urgency, and the performative shock that dominates our information landscape right now. The Supreme Court of the United States rejected an appeal. That's the structural fact. An appeal was filed. The court reviewed it, or more precisely, declined to take it up, and the decision below stands. There's no dramatic reversal, no emergency intervention, no last-minute legal acrobatics, just a decision that says the process has concluded, the answer is no, and the matter proceeds according to the law as written and interpreted through the systems designed to handle exactly this kind of question. Now, I know how this lands in the current media environment. The phrase, "it's over," gets attached to the headline. Someone reacts. The algorithmic velocity kicks in. The emotional charge spreads faster than the actual legal meaning. And within minutes, millions of people are absorbing not the decision itself, but the feeling of the decision, the sense that something monumental has shifted, that a door has closed, that finality has arrived, and maybe it has. But let's be very careful here. Let's separate the legal mechanics from the political theater. Let's distinguish between what the Supreme Court did and what people want it to mean. Because in moments like this, when institutions make decisions that carry political consequences, the distance between structure and interpretation becomes the place where clarity either survives or dies. The Supreme Court rejecting an appeal is not in itself unusual. The court receives thousands of petitions each term. It agrees to hear a tiny fraction of them, usually fewer than 80 cases a year out of more than 7,000 requests. Most appeals are denied. Most cert petitions go nowhere. The denial doesn't mean the lower court was right or wrong in some cosmic sense. It means the Supreme Court has decided not to intervene. That's a procedural outcome. It's not a moral verdict. It's not a philosophical endorsement. It's the court saying, this matter does not require our involvement at this time, or the legal question does not meet the threshold for review, or the decision below is sufficient as it stands. But when the name attached to that appeal is politically charged, when the context is a former president, when the stakes involve accountability, power, and the boundaries of legal immunity, then that procedural denial becomes something else entirely in the public mind. It becomes a referendum, a climax, a conclusion to a long story, and people react accordingly. So let's talk about what this decision actually means in structural terms, and then we'll expand outward to what it reveals about the systems we're living inside, the pressures they're under, and the long-term dynamics that govern how institutions behave when political gravity pulls hard in one direction. Here's the first thing people misunderstand. The Supreme Court's refusal to hear a case is not the same as the Supreme Court ruling on the merits. When the court denies certiorari, that's the legal term for declining to review a case, it's not saying the lower court got it right. It's not saying the lower court got it wrong. It's simply saying we are not taking this up. The prior ruling stands. The legal process continues or ends based on what has already been decided below. This is crucial because the media environment, the political commentary, and the public reaction all tend to treat a denial as if it's a ruling, as if the 9 justices sat down, debated the matter, weighed the arguments, and came to a conclusion. But that's not what happened. What happened is much quieter. A petition was filed. The court reviewed the petition, not the full case, just the request for review. And the justices decided, either unanimously or by majority, that the case did not meet the criteria for Supreme Court intervention. Why might that be? There are several reasons the court denies cert, and none of them have to do with the drama of the political moment. Sometimes the legal question isn't ripe. Sometimes the issue has already been settled by precedent and there's no circuit split to resolve. Sometimes the case is fact-specific and doesn't present a broad constitutional question. Sometimes the court simply doesn't want to wade into a politically charged matter unless it absolutely has to. And sometimes, this is important, the court agrees with the outcome below and sees no reason to disturb it, even if it doesn't want to write a full opinion saying so. So when the Supreme Court denies an appeal in a case involving a former president, what you're seeing is not necessarily a judgment on the former president's guilt or innocence, or even on the legal theory being advanced. What you're seeing is the court deciding that the lower court's handling of the matter is sufficient, that the legal framework is clear enough, and that Supreme Court intervention would not add clarity or resolve an ambiguity that demands resolution. That's a structural decision. It's about jurisdiction, procedure, and the limits of appellate review. It's not about politics, even though the consequences are entirely political. And this is where the noise begins to overwhelm the signal, because in the public square, the structural meaning gets flattened. The decision becomes a symbol. It becomes a win or a loss. It becomes evidence that the system is working or proof that the system is broken, depending on which side of the political divide you occupy. But if you're trying to understand what actually happened, if you want to see the mechanics clearly, you have to resist that flattening. You have to hold on to the distinction between what the court did and what people want it to mean. Let's walk through the sequence step by step, because understanding the timeline and the procedural layers is essential to understanding why this moment feels significant, even if the legal outcome was, in many ways, predictable. An appeal was filed. That appeal likely stemmed from a lower court ruling, perhaps a circuit court, perhaps a district court decision that was affirmed on appeal that went against the party now seeking Supreme Court review. The legal question at the heart of the appeal probably involved immunity, executive power, the scope of presidential privilege, or the boundaries of accountability for actions taken while in office or in the course of a campaign. These are not small questions. They are, in fact, some of the most consequential questions in American constitutional law. But they are also questions the courts have been grappling with for decades, if not centuries. The presidency is a unique office. It carries enormous power. And the legal system has long struggled with how to balance that power against the principle that no one is above the law. So the appeal arrives at the Supreme Court. It's docketed. The justices review the petition. They discuss it in conference. This happens behind closed doors, no cameras, no transcripts. They vote. If 4 justices want to hear the case, it gets added to the docket. If fewer than 4 want to hear it, the petition is denied. In this case, the petition was denied. That means fewer than 4 justices thought the case warranted full briefing, oral argument, and a written opinion. It means the court, as a body, decided that the legal question either didn't need answering or had already been answered sufficiently by existing precedent and the lower court's reasoning. Now, it's possible that 1 or more justices dissented from the denial. Sometimes you'll see a dissent from a denial of cert, where a justice writes a short opinion explaining why they think the court should have taken the case. That's a signal. It tells you there's division on the bench or that a justice believes an important legal principle is at stake. But even then, the denial stands. The lower court ruling is final. And that's where we are now. The ruling below, whatever it said, however it framed the legal question, is now the law of the case. There's no higher court to appeal to. There's no procedural avenue left unless new facts emerge or a different legal theory is pursued in a different case. For this particular matter, this particular appeal, the process has reached its end. That's what "it's over" means in structural terms. Not that accountability has been achieved or avoided, not that justice has been served or thwarted, but that the legal process, as designed, has concluded. The system has spoken. And the answer is no further review. Now let's zoom out, because this decision doesn't happen in a vacuum. It happens at a moment when the Supreme Court itself is under extraordinary scrutiny, when its legitimacy is being questioned from multiple directions, and when every decision it makes or refuses to make is read as a political signal. The court has always been a political institution in the sense that its members are appointed by elected officials and its decisions shape the distribution of power in society. But there was a time when the court's political nature was softened by a widespread public belief in its neutrality, its commitment to legal principle over partisan advantage. That belief has eroded significantly over the past 2 decades. The court's composition has shifted. The confirmation battles have become more contentious. The decisions on voting rights, reproductive rights, executive power, and corporate influence have all been perceived, rightly or wrongly, as aligned with partisan interests rather than neutral legal interpretation. And the result is that a large portion of the public no longer views the court as an impartial arbiter. They view it as another political actor, one whose decisions are determined more by the ideology of the majority than by the Constitution itself. I'm not here to adjudicate whether that perception is fair. I'm simply stating that it exists, and it matters, because when the Supreme Court denies an appeal in a politically charged case, both sides interpret that denial through the lens of their prior beliefs about the court's legitimacy. If you believe the court is captured by conservative interests, you might see the denial as a refusal to hold power accountable, as a signal that the court is protecting a former president from consequences. If you believe the court is still a neutral institution, you might see the denial as a sign that the legal arguments in the appeal were weak, that the lower court got it right, and that the system is functioning as intended. Both interpretations are plausible. Both are grounded in the same factual event, but they lead to completely different conclusions about what the decision means and whether it represents justice or its absence. This is the nature of institutional stress in a polarized environment. The institution's actions are filtered through partisan lenses. The structure remains the same. The court still operates according to the same rules, the same procedures, but the public's trust in that structure is fragmented. And when trust is fragmented, every decision becomes contested, every denial becomes suspect, and the institution's ability to generate legitimacy through its process alone begins to weaken. That's not collapse, that's not failure, but it is strain. And it's the kind of strain that accumulates over time, that builds pressure inside the system, and that eventually forces a reckoning, either through reform, through a restoration of trust, or through a deeper erosion that changes the nature of the institution itself. Let me offer a framework for understanding how institutions behave under pressure, because it applies not just to the Supreme Court, but to every major institution navigating this era. When an institution is under stress, when its decisions are scrutinized intensely, when its legitimacy is questioned, when the stakes of its actions are perceived as existential, it tends to move in one of three directions. First, it can assert itself aggressively. It can take bold action, issue sweeping rulings, wade into the most controversial questions, and use its authority to reshape the landscape. This is the path of institutional confidence. It says, we have the power, we have the mandate, and we will use it. Second, it can retreat into minimalism. It can avoid the hardest questions, decline to intervene, issue narrow rulings that resolve the immediate case without setting broad precedent. This is the path of institutional caution. It says we will do what is necessary, but we will not overreach, and we will not invite more conflict than we can manage. Third, it can fracture. It can lose coherence, with different factions pulling in different directions, with dissents and concurrences multiplying, with the institution's voice becoming fragmented and its authority diluted. This is the path of institutional erosion. It says, we no longer have consensus, and our decisions reflect division rather than clarity. Right now, the Supreme Court is navigating between the first and second paths. On some issues, it has been aggressive, overturning long-standing precedent, reshaping constitutional doctrine, asserting its vision of the law. On other issues, it has been cautious, declining to take up controversial cases, issuing narrow rulings, avoiding the most politically explosive questions. This denial of cert likely falls into the second category. It's a decision not to decide. It's a choice to let the lower court's ruling stand, to avoid the spotlight, to not engage with the broader political narrative. And that choice in itself is revealing. It tells you that the court, or at least a majority of the justices, does not see this as the moment to assert itself on this particular question. It tells you that the legal arguments were not compelling enough, or the political costs of intervention were too high, or the procedural posture was not right. It tells you that the court is, in this instance, choosing caution over boldness. And in a polarized environment, caution is often the wiser path, because bold action invites backlash, invites accusations of partisanship, invites the very legitimacy crisis the institution is trying to avoid. Caution preserves optionality. It allows the court to say, we did not rule on the merits, we simply followed procedure, and the outcome below stands. That may not satisfy anyone. It may feel like evasion to those seeking accountability and like relief to those fearing overreach. But it's the strategy of an institution under stress, trying to navigate a landscape where every move is interpreted politically and every decision carries the weight of institutional survival. Let me offer a cross-domain analogy because it helps clarify the dynamics at play. Imagine a large corporation. The CEO steps down. Maybe they retired. Maybe they were forced out. Maybe they left under a cloud of allegations. But they're gone. Now, the board of directors has to decide. Do we pursue legal action? Do we investigate the former CEO's conduct? Do we defend them if external parties bring claims? Or do we simply move on, focus on the future, and let the past settle itself? This is not an easy decision. The board has competing interests. Some members may have been loyal to the former CEO and want to protect their legacy. Others may believe accountability is necessary to restore trust. Still others may worry that a prolonged legal battle will distract from the company's operations and damage its reputation. So the board weighs the options. They consult lawyers. They assess the strength of the legal claims, the likelihood of success, the potential costs and benefits. They think about precedent. How have other companies handled similar situations? They think about stakeholders. What do shareholders want? What do employees need to hear? What will the public perceive? And eventually, they make a decision. Maybe they pursue action. Maybe they don't. But the decision is made not in a vacuum, not based solely on the merits of the case, but in the context of the institution's broader interests, its strategic position, and the long-term consequences of each path. The Supreme Court's decision to deny cert operates in a similar space. The court is not a board of directors, and the law is not corporate strategy, but the institutional logic is comparable. The court has to weigh not just the legal question, but the implications of engaging with it. It has to think about precedent, about workload, about the political environment, about the signal its decision will send. And in this case, the court decided that intervention was not warranted. The lower court's ruling stands. The process concludes. The institution moves on. That doesn't mean justice has been served or denied. It means the institution has made a strategic decision about where to spend its authority, how to allocate its limited bandwidth, and which battles are worth fighting. And that, more than any single ruling, is how institutions operate under pressure. They triage, they prioritize, they make decisions not just about what is right, but about what is sustainable, what is defensible, and what preserves their ability to function over the long term. Here's a principle I want you to hold on to. In moments of institutional decision-making, the noise is not the danger. The silence is. Right now, there is tremendous noise around this Supreme Court decision. Headlines blaring, reactions flying, political figures weighing in, the algorithmic machinery of social media amplifying every hot take, every emotional response, every claim that this changes everything or means nothing. But the noise is not where the real story is. The noise is theater. It's the surface level reaction, the immediate emotional discharge. It's necessary in a democracy because people need to process events, to express their views, to feel heard. But it's not where the structural change happens. The silence, the absence of Supreme Court intervention, the decision not to engage, the procedural conclusion that happens quietly without fanfare, that's where the power lies. Because silence is a choice. Inaction is a decision. And when an institution as powerful as the Supreme Court chooses not to act, that choice shapes the legal and political landscape just as much as any ruling would. The denial of cert is silent in the sense that it doesn't generate a written opinion, doesn't produce pages of legal reasoning, doesn't give commentators much to analyze. It's a one-line order, cert denied. But that one line carries enormous weight. It means the lower court's reasoning is now the final word. It means the legal question, for now, is settled. It means the precedent stands, the boundaries are drawn, and the system is spoken. And that silence, that quiet procedural conclusion, will outlast all the noise. 6 months from now, the headlines will be forgotten. The hot takes will have faded. But the legal reality created by this denial will remain. Cases will cite the lower court ruling as binding. Lawyers will structure their arguments around it. Future litigants will navigate the landscape it creates. This is why I always tell people, pay attention to what institutions don't do as much as what they do. Pay attention to the cases the court declines to hear, the questions it avoids, the moments when it steps back rather than forward, because those silences reveal the institution's strategy, its priorities, its assessment of risk and reward. In this case, the silence says, we are not intervening. The system below has handled this. The process is sufficient. The legal question does not require our involvement. And whether you agree with that or not, whether you see it as justice or evasion, it is the reality. The structure has operated, the outcome is set, and the noise, however loud, does not change it. Now let's talk about how ordinary people absorb a moment like this, because the gap between legal mechanics and public understanding is vast, and that gap matters. Most people do not follow the Supreme Court closely. They do not understand the cert process, the difference between a denial and a ruling on the merits, the procedural nuances that determine which cases get heard and which don't. What they understand is the headline, Supreme Court rejects Trump's appeal. And from that headline, they construct a narrative. For some, the narrative is, finally, accountability. The system worked. The court stood up. Justice is being served. For others, the narrative is, this is political persecution. The courts are weaponized. The system is rigged. And for still others, the narrative is, I don't know what this means, but it sounds important, and I'll wait to see what happens next. All of these narratives are built on the same factual foundation, but they diverge dramatically in interpretation. And that divergence is not random. It's shaped by prior beliefs, by political identity, by media consumption, by trust or distrust in institutions. This is the challenge of democratic governance in a fragmented information environment. The same event is experienced in radically different ways. The same institutional action is read as heroism or villainy, depending on the lens through which it's viewed. And the result is that there is no shared reality, no common understanding of what just happened and what it means. This is not new. Political polarization has always produced competing narratives. But the speed and intensity of that polarization, amplified by digital media, has made the divergence more extreme. People are not just interpreting events differently. They are living in different informational universes where the basic facts are filtered, where the context is selectively presented, and where the conclusion is often predetermined by the source. So, when the Supreme Court denies cert in a high-profile case, the legal outcome is singular. The ruling below stands. But the political and social outcomes are multiple. For some, it's a turning point. For others, it's a non-event. And for still others, it's evidence of systemic dysfunction regardless of the direction. What matters, from a systems perspective, is not which narrative is correct. There is no objective arbiter of correctness in political interpretation, but how those narratives shape behavior. Do they increase trust in institutions or erode it further? Do they mobilize civic engagement or deepen apathy? Do they encourage people to participate in the legal and political process, or do they convince people that the process is broken beyond repair? These are the downstream effects of institutional decisions, and they unfold slowly over months and years as people integrate the decision into their broader worldview and adjust their behavior accordingly. Let me place this moment in a longer historical frame, because what we're witnessing is not unprecedented. It's part of a recurring tension in American governance. The question of how to hold powerful people accountable without destabilizing the system itself. Every democracy faces this tension. Leaders accumulate power. They make decisions with enormous consequences. And when they leave office, the question arises, can they be held accountable for their actions? Should they be? What are the mechanisms and what are the limits? In the American system, that question has been answered in different ways at different times. Sometimes accountability comes through the ballot box. Leaders are voted out, their policies reversed, their influence diminished. Sometimes it comes through impeachment, though that process is political and rarely results in removal. Sometimes it comes through the courts, though the law has long struggled with how to apply legal accountability to actions taken in an official capacity. The Supreme Court has played a role in shaping these boundaries. It has ruled on executive privilege, on presidential immunity, on the scope of powers held by the office. And each ruling has been contested because there is no neutral answer. Every decision about accountability is also a decision about power. Who has it, how it can be checked, and what happens when it is abused. This denial of cert is part of that long arc. It's a decision about where the boundaries lie, about how far the legal system can and should go in holding a former president accountable. And like every such decision, it will be debated, interpreted, and reinterpreted as the political context shifts. But here's what history tells us. Institutions endure not because they always make the right decision, but because they make decisions according to a process that people broadly accept as legitimate. The process may be slow, it may be frustrating, it may not deliver the outcome any particular faction desires. But as long as the process is perceived as fair, as grounded in rules rather than arbitrary power, the institution retains its authority. The Supreme Court's denial of cert is, in that sense, an assertion of process. It says, this is how the system works. Appeals are filed. They are reviewed. Most are denied. The lower court's ruling stands. That's not drama. It's not a climax. It's just the system doing what it was designed to do. And whether that system is adequate to the challenges of this moment, whether it can deliver accountability in a way that satisfies a polarized public, whether it can balance the need for justice with the need for stability. Those are open questions. But the system is still operating. The structures are still intact. And the decisions, however contested, are still being made according to rules. So where does this leave us? What happens now that the Supreme Court has denied this appeal? First, the legal process continues or ends, depending on what other avenues remain. If this was the last possible appeal, then the lower court's ruling is final. The legal question is settled, at least for this case. If there are other legal proceedings, other charges, other claims, then those will proceed according to their own timelines and procedures. But this particular appeal, this particular request for Supreme Court intervention is over. Second, the political narrative will shift. Those who view the denial as a victory will celebrate it as evidence that the system works, that accountability is possible, that no one is above the law. Those who view it as a defeat will decry it as further proof of systemic bias, of political persecution, of a legal system weaponized against their interests. And those narratives will harden, will be amplified by partisan media, and will shape how people engage with the next chapter of this story. Third, the institutional strain will continue. The Supreme Court is not suddenly going to regain universal legitimacy because it denied this appeal. If anything, the decision will deepen the polarization around the court itself. Those who wanted intervention will see the denial as cowardice or complicity. Those who opposed intervention will see it as appropriate restraint. And the court will continue to navigate a landscape where its every decision is interpreted as political, where its authority is contested, and where its role in the constitutional order is being renegotiated in real time. But here's what I want you to understand. None of this is collapse. This is how systems under stress behave. They strain, they adapt, they make decisions that satisfy no one completely, but that keep the machinery turning. And over time, either the stress eases because the political environment changes, because new leadership emerges, because the crisis passes, or the system evolves, reforms itself, or breaks down in ways that force a deeper reckoning. We are not at the breaking point. We are in the strain. And the strain is uncomfortable, but it is also, in a strange way, evidence that the system is still functioning. It's still processing disputes. It's still making decisions. It's still holding together under pressures that in other times and places have torn systems apart. That doesn't mean the system is perfect. It doesn't mean the decisions are always just. It doesn't mean we should accept dysfunction as inevitable. But it does mean that the work of governance continues, that the structures still matter, and that the long-term trajectory is still shaped by engagement, by pressure, by the choices people make about whether to participate in the system or abandon it. Let me distill a few principles from this moment because they apply far beyond this single Supreme Court decision.